Okay, good afternoon everyone. Welcome to the foundation batch of the Facto IAS Judiciary. So we are going to start with how we are going to go about the foundation batch. So it has been strategically created for 16 months. In 16 months, we will be covering around 26 subjects. Why we have come for 16 months here? Because usually these preparation for judiciary, it takes a lot of time. In many coachings, they take about two years to complete the whole course. But for judiciary exams, it's not very specific like your UPSC exam. The notifications for every state come about any time. It can drop in February, it can drop in March. It depends on state to state when the notification comes out. But when the notification comes out, how much are you ready to give the exam? That is the question. So basically these 16 months we have allotted for our judiciary batch so that you are ready to give the exam as soon as the notification arrives. We will try to cover, we will divide these 16 months in 4 months batches. First, like the one that is starting in April now, then August, then December, and so on. And in all these batches, we will be covering major subjects in each of them. Like one major subject will be covered in each batch so that whatever students are joining us in every batch, they are able to cover one major subject. What we need to understand is the major subjects in your judiciary syllabus, like your CPC, like your evidence, BS, your CRPC, and IPC, contract. These are all major subjects that are common in all your judiciary exams, and they usually have a weightage of at least 25% of each subject in every exam. So the more time these subjects take, the less you will be able to score in your exam. Suppose your exam has arrived and the notification is out. So even if 3 of these subjects are covered, you will be able to score more in your prelims, practice more for your next time, and you will be more ready in your judiciary exam, whichever state is coming on. So what we are going to do is that we are going to allot 16 months for these 26 subjects, so that in time we are able to cover everything that is required for you to able to give your exam perfectly and on time and have the full knowledge before sitting in your prelims, in your mains, and also other related topics that are covered in, like suppose your general knowledge and English is also important. We will also be covering that as well. So 26 subjects, how have we selected these 26 subjects out of 29 states? 29 states we are going to deal with, including your Delhi, which is your union territory. So we are going to deal with all the 29 states, including Delhi. The syllabus of all these 29 states have been properly vetted, and then we selected 26 subjects out of these of the syllabus of these 29 states and Delhi. And how this has been selected is that these 26 subjects are mostly common in all these 29 states. They are mostly common in all these 29 states. So when we will deal with all these subjects, and special focus obviously has been given to Delhi. Delhi municipal laws, Delhi Rent Control Act, Haryana Rent Control Act, they will be dealt separately in classes. So special dedication has been given to Delhi Judicial Services. As for all the other states, we are covering mostly all the subjects that are being covered in all your state exams. All your state exams, we have taken out 26 subjects out of all your state exams, which will able you to cover almost all the subjects that are there in your state exams. So what about the local laws of these subjects, of these exams? Suppose if you have Himachal or if you have UP, these all have their local laws. Let's say it's Rajasthan Judicial Services, then we have to deal with Rajasthan Rent Control Act, Rajasthan local laws. So for your local laws, these 26 subjects, these are common in all your states. Okay, we will be dealing with them properly from basics to how you're going to approach the prelims, how you're going to approach the mains for this. After these 26 subjects, we will also address the local laws. Suppose you're targeting Rajasthan Judicial Services or you're targeting UP Judicial Services. Then when the notification arrives and suppose your 26 subjects are done and there are local laws that need to be addressed with, we will also give you notes for this depending on the state you are targeting, and we will also give you counseling for this, that how you have to approach the specific strategy to approach that local state that you are targeting. So we will do both of these things. Your local laws will be addressed and the notes will be given for this, the questions that come out of these local laws, and also the counseling will be given to you according to your state that you are targeting. So to sum up, we have 26 subjects that we are going to deal with in a span of 16 months. There will be 2 classes of 2.5 hour each, class 1 and class 2. Your first class will start from 10 a.m. to 12:30 p.m. and your second class will start from 1 p.m. to 3:30 p.m. This will be Monday to Friday, and we will cover everything, all the 26 subjects in these classes in 16 months. All your 26 subjects will be covered. Due assurance have been taken that all the subjects will be covered in 16 months, so you are ready to give your exam in as soon as the notification arrives and most of your subjects are covered, because if the batch is of more than 16 months, then it takes a lot of time. First of all, you're doing your LLB for 5 years, and then to go through a whole 3-year process to prepare for judiciary. I think that is a little rigorous. So we will try to finish, we will definitely finish the syllabus in 16 months. So this is your whole schedule of your new foundation batch. Your class 1 at 10 to 12:30 and class 2 at 1 to 3:30 p.m. 26 subjects spread across, taken from at least 29 states. We have taken in consideration all of the states, Arunachal Pradesh, Assam, we have taken Andhra Pradesh, all your southern states, we have taken in consideration, and then we have taken out these 26 subjects for our syllabus. Apart from this, what we see is that in the local subjects, in the states, in other states, there is also a language paper. There is a language paper, like for Assam, there is an Assamese language paper. There is a Marathi language paper for different states. This language paper we will not be dealing with, but we will be providing you, like if there is the mains paper, your whole mains paper, they consider of different papers, your civil law paper, your criminal law paper, and then there's a language paper. So this language paper is what you have to deal with on your own for your own states. Otherwise, your local laws, your major syllabus, your major subjects, Your general knowledge, your English writing, your translation, everything will be dealt with here. We will be giving you notes. There will also be counseling for whatever doubts, whatever problem the students are facing. So everything will be addressed here. All right. So moving on, we will, if you're a beginner, this judiciary exams. I would like to give you an introduction for how to approach these judiciary exams. Suppose you're a beginner, or maybe if you're not a beginner, you have already given a prelims, you're already preparing. Still, I will give you a overview of how to approach these judiciary exams. What is the format of these exams? What are the stages in this exam? And how we are going to help you in each stage in our batch. That's what I want to explain it to you. So first stage is your prelims, your preliminary exams. Second stage is your mains exam. And third stage is your interview. And after this, you become a judge. But the whole journey is not so easy, and it is hard to do without some guidance. Many of you might think that maybe it's easy to do without guidance, but to approach any judiciary exam as a beginner, it is very important that you have some guidance so that you do not waste your time doing something that you should not have been doing, and getting the right guidance is also very important. So for your preliminary exams, what is the structure of your preliminary exam? For different states, it is very different. For Delhi, it's different. For Haryana, it's different. For Rajasthan, it's different. For Assam, it's different. For different states, let's take the example of all 30 states, and all of them have a very different format. What is common is our 26 subjects that we will be teaching. All your questions in all these preliminary exams will be coming from these subjects, and the general knowledge part and the English part that we will be teaching you. But the format is different in different states and union territories. Suppose in Delhi, there are 200 questions. Like there are 200 questions of 1 mark each, and there is negative marking also. In Haryana, there are like 125 questions of 4 marks each, and there is negative marking. In Rajasthan also, there are 100 questions of 1 mark each. In Assam, there are 100 questions of 1 mark each. In UP, the format is entirely different. The preliminary exam is divided into 2 parts. In 2 parts, first part is your GK and language, and the second part is your law paper. So this part is of 50 mark, and this part is of 150 mark. Similarly, for Bihar, it is also divided into 2 parts, that one paper is of your GK and language, and one paper is of your law. So for different states, the format is very different. Depending on the state that you are targeting, your approach has to be in the same way. Why? Because when you are targeting a particular state, suppose you're targeting Delhi, then you should be able to answer 200 questions within that time. If you're targeting Haryana, then you should be able to answer 125 questions within the particular time. So you have to make depending on the state that you're targeting, you have to make your mind frame according to that the preliminary exam will take place, and you have to answer the A, B, C, D in a particular time. What is very essential, very important for every preliminary exam is the time. That you answer the questions on time, and for that you have to make your mind frame in a way that I have to answer 200 questions in this particular time, I have to answer 125 questions this particular time. Apart from this, of course, the content, the knowledge is very important. Your time management and your knowledge. If you have the knowledge to answer the questions, then time will not matter, because as soon as you see the question, you will be able to click it immediately. So your knowledge is obviously extremely important when it comes to your preliminary exams. Now this knowledge we will provide you. We will provide you in a way that as soon as you see the exam question in the preliminary exam, you are able to target it immediately without even thinking twice. This is the strategy to clear prelims exam. Prelim exam can only be cleared if you practice well, your concepts are clear, and you ensure that you have the time management for it. Sometimes it is very confusing what the answer would be between 1, 2, 3 and 4. Sometimes 2 and 3 are very similar. To target this, that which of the answer between 2 and 3 is the correct answer, is what we will tell you in these classes. We will ensure that every week after every subject, we will be giving you 25 questions on the topic that is dealt with, and those 25 questions will address everything that has been done in the week. So that your journey, your initial journey is in a way that you're able to target every question from the very start. You remember every section, every important case law that has come related to that topic. So we will go slow and we will approach the questions in a way that you're able to target everything in time and nothing will be missed out. So when we talk about preliminary exam, it is the first stage, and what is important is that we cannot distinguish between preparing for a preliminary exam and preparing for a mains exam. Your preliminary exam, although it's a multiple choice question, it is as important as your mains exam, because you cannot reach here unless you have cleared this preliminary part. So preliminary exam, whenever we are dealing with a subject, suppose like today I'm going to deal with contract. So let me give you an example of how we are going to deal with contract in your preliminary exam, or how do you approach every subject that we will be teaching, how will we approach these subjects according to our preliminary exam and according to our mains exam. When we deal with contract law, your bare act is extremely important. So whenever the questions are coming from a bare act, there are specific sections that are repeatedly asked in these exams. There are specific case laws that are repeatedly asked in these exams. And as and when we are going through the whole bare act, all topics that we are going to deal with, we will be making you note down these sections, and not just note them down, we will also make you practice them repeatedly so that it is entirely submerged in your head, in your minds, that what this sections is related to. Like as soon as you think of that section, you know what it is related to. And this is what is important for the preliminary exam. For the preliminary exam, the section should come to your mind with the attached title, and it should strike you immediately, because sometimes the questions are direct. What is section number 17 of Indian Contract Act? They will ask you directly. What is section number 19? What is 18? What is 16? So they will ask you directly many a times, and sometimes to whoever has learned these bare act sections by heart, and will make you note down what are those important sections that you have to learn by heart. And to target the prelim exams of major states, maximum number of states, this is enough. This will be enough to clear the exam. Of course, there are exceptions like Delhi, now Haryana also, they have also started making their preliminary exam more complicated. If you see the last year's paper of 2024 DGS exam, you will notice there are many questions that are extremely direct. That are literally direct from the section itself. There is not a lot of sentences in the question. Although in previous papers of Delhi, there were a lot of theory first in the question and then the answer. So what we need to understand, especially for all other states, if we leave out Delhi, we target all other states. Many states, majorly all states, the sections are very direct. The questions are very familiar. The questions are very common. If we target only the common sections first in the prelims exam, we realize that 60% of our work is done. 60% of the paper we have already attempted in a very correct way. But when we move on, when we come to our recent developments, your legal developments, that's where we have to work upon separately. And that also we will be giving you. We will be giving you all the important judgments related to every subject. If there is a contract, if we are talking about the subject of contract, and there is an important judgment related to section number 73, your breach of contract, your compensation, we will hand it out to you. So all the judgments of the Supreme Court and the relevant High Court. Suppose Supreme Court judgments are your Magna Carta, obviously, but suppose you're targeting a particular state. You're targeting a particular state. Suppose you're targeting Haryana, you're targeting Rajasthan, then Punjab and Haryana High Court's judgments becomes extremely important to you. If you're targeting Rajasthan, then Rajasthan's High Court's judgment becomes important to you. If you're targeting Delhi, then your Delhi High Court judgments becomes important to you. So depending on what state you're targeting, their High Court's judgments will become very important for you, plus your Supreme Court judgments. You have to keep a track on what the particular High Court is saying about the particular section that is in our syllabus that we will be learning, and we will make you keep a track of all the important judgments, the Supreme Court judgments as well as the relevant High Court, depending on what state you are targeting. We will be focusing on some High Courts, and depending on our students, what the states they are targeting, we will target those particular High Courts as well. So you have a track of all the important judgments from these High Courts. So this part also covers your almost 20% of the prelims paper, your legal developments. Then for UP, Haryana, GK is very important. Your UP exam, your Bihar exam, also for other states as well, your GK and your current affairs is also very important. We will also be targeting them. We will giving you judiciary current affairs are uploaded every week on the website. They are specifically curated in a way that you get all the latest information that is related to judicial exams in your current affairs, and your GK will also be targeted here, your history, geography. Separate classes will be given for all of these subjects as well. So nothing is left out to crack the exam. So to talk about only prelims, you have gotten our strategy to approach the exam. We know the format of the exam, how you are going to target your own state, that is important. Then each subject, how it will be approached in a way that you're able to answer all the preliminary questions. We will be giving you rigorous practice of preliminary questions, because that is the key way to clear the preliminary exam. Now this is your first stage that I dealt with. After your first stage, we come to your mains exam. I hope it is clear what, I hope it is clear what I meant by clearing the first stage. And I hope I'm clear about the strategy that we are going to keep and how we are going to approach the subject. Any doubts regarding this? Anyone online? Any doubts regarding this? Okay, so let's move on. Now we will deal with the mains strategy. For our mains exam, your mains examination is obviously the most main exam of the judicial service. This will test your knowledge, everything that you have prepared in your journey of judicial services. Judicial service exam, this will be tested in your mains exam. So your mains exam is extremely important. How you have to approach this exam, first of all, to understand the format of these exams. For different states, obviously, there is a different format. But what is common is the civil law paper. There will be one civil law paper, which will contain all the laws, all the minor acts related to your civil laws. Your SOGA will be here, your partnership will be here. A lot of subjects that are related to your civil laws will be in your civil law paper. There is another paper of civil law which usually targets your procedural civil law, like your CPC, your limitation, your registration. Another common paper is your criminal law. Criminal law paper, it will be, all your criminal laws will be here. Usually women and child law will be here, POXO or POSH, and your JJ Act is also here. Your Negotiable Instrument Act is also here. So in criminal law, civil law, there are two papers. In criminal law, there is one paper. In major states, most of the states, the format is the same, that there are two civil law papers. Usually there is one civil law paper also. They combined all in one. But in the criminal law paper is common in all the states. This is one format. Okay. Then there is another paper which is your GK paper, your general knowledge paper. Sometimes your general knowledge paper is combined with your language paper. Suppose like in Delhi, there is a GK and language paper which is common. But in other states, there may be a GK paper separately, and there might be a English paper separately, and there will be a Hindi paper separately, or there might be a local language paper separately. Like suppose for the Assam, there will be an Assam language paper separately. Okay, so all these papers are like paper 1, paper 2, paper 1, paper 2, paper 3. For different states, there are different formats. So for some states, there can be a format like this, paper 4, this will be paper 5, or this will be paper 6, this will be paper 6. So there's a Hindi or local language paper as well. So to understand this, and for some states there are also local laws paper that are separately, like for UP there is a separate local laws paper because there are a lot of local laws in UP. But usually the local laws are usually included in the civil law papers itself in major states. So this is your format. This is all we have to study for our mains exam. Your civil laws, your criminal laws, a good knowledge of your general knowledge part, your recent legal developments, your language part which will deal with composition, essay, précis, translations. Then there could be a separate GK paper, then to again deal with legal developments, maybe international law as well. Then English, there could be a separate English paper like it is in Haryana. So in Haryana, there is a separate English paper. They also ask you synonyms, antonyms. They will ask you to make sentences out of words, English words. There will be précis, there will be translation. Then there's a Hindi paper. In Hindi paper, there are usually translations. They might ask you to write an essay in Hindi. If we talk about Haryana, then also there is Padyansh and Gadyansh that is addressed in these papers. So to understand this format, now also you understand a common format for all the states now. Now what we need to understand is what is our particular state. Now according to your particular state, your strategy will be different. Suppose you're targeting Delhi, or suppose you're targeting Haryana, or suppose you're targeting Rajasthan. Whatever state that you're targeting, your strategy will be accordingly. As soon as you select your state, suppose you select Delhi is your state, then you know there is paper 1, civil law 1, there is paper 2, civil law 2, there is paper 3, which is your criminal law, and there is paper 4, which is your GK and English. And now you know out of these papers what you have to focus on and what your strategy has to be. So for every state you have to make a different strategy. If there is a different local law paper, then you will allot time to that paper as well. And depending on your state, we will also give you notes for that local law. And we will also give you counseling about and also question answers about how the local laws will be addressed. We will not leave the local laws out because they are extremely important for every state. If you are targeting a state and you leave the local laws out, you cannot pass the paper. For every exam, it is important that you are able to pass all the papers. There is a minimum criteria to pass all the paper. If you pass for paper 1 and you fail paper 2, you're not going to make it. And not just pass, you also have to score high in the mains paper. So how will we score high? How will we score high in the mains paper? That is also important. So for your mains paper, when we are targeting all these paper 1, 2 and 3, we are dealing with all the 26 subjects again. We are dealing with all the 26 subjects again that will come in your mains exam. When we are dealing with them, we will be telling you the class notes. The class notes will be in a format in how you will write the answers for your mains questions. The class notes, they will be in a format that how you write your question and answers. Okay, this will help you answer the questions properly and not waste time on a lot of theory. Your theory will be straightforward. Whatever is important, we will be giving you the printed notes which has a lot of theory, and your strategy should be to first you will see your printed notes properly and you will understand all the basics through this, and then there will be your class notes. Your class notes will be very crisp, very to the point, with all the important judgments. Nothing will be left out in it, and also we will take special classes for how you will address your mains questions, how you will structure the answers. Everything will be addressed here. All the important judgments will be given to you. The class notes will be very important. So your strategy has to be to approach the mains exam to consider these class notes as your holy grail. Because when your exams arrive and then you're revising your syllabus, these class notes will be very important to you because you will be revising them again and again and again, and then you will be able to remember what are the landmark case laws to a particular section, what are the landmark recent case laws to a particular section, what are the important ingredients of this particular section, and you will target everything straightforward. The golden rule for every exam is that you remember the legal terms plus the case laws plus the illustrations. If you remember these three in every answer, you will be able to score a very high score. You will be able to make a very high score out of every answer. If there is a 10 marker, we want to ensure that you're able to score between 8 and 9, and that we will do through our case law class notes that we will be giving you. Your class notes will be very crisp, to the point, and it will be exactly how you target your mains answer. All the previous year questions will be dealt with. We will deal with a lot of previous year questions that are commonly comes in your exams, and we will also deal with a lot of potential questions that can come in your exam, and we will also dedicate some classes specially to the format and structure of an answer. We'll check the copies personally, and we will dedicate how your answer has to be. The structure and format of the answer will be worked upon, so as we can score a very high score of 8 to 9 marks if the question is of 10 marks. So how will we do that? We will make sure that these 26 subjects are addressed very strategically to you, and that's so that you don't waste your time. You have everything in your hand, in the palm of your hand, when you're reading your class notes or you're revising stuff. All the latest case laws will be handed over to you, and everything that is related to the particular topic, any legal development, that will also be handed over to you. Nothing will be missed out when you are talking about mains. Your personal effort, of course, is very important. No amount of guidance can be is useful as long as there is no personal effort. So your personal effort is also very important. So this is how your mains will be targeted. First of all, what your local state you're targeting, if there are 2 or more, according to that. Then the format of the paper, we will explain it to you, and then we will target each paper very strategically. If there is a language paper, let's say we dealt with civil law and criminal law. We know we are dealing with civil law and criminal law. We are dealing with these subjects, that is our classes. We will give you the questions every week, what the commonly coming questions are in the exams, and according to the states as well, we will give you. Suppose also the local laws, if there are questions related to local laws, then we will also give those questions for your mains exam. Now, we have to understand in civil law and in criminal law, there are some minor subjects and there are some major subjects. So obviously the minor subjects, the weightage is low. Their weightage is low, and the major subject, the weightage is very high. So what our focus has to be is on major subjects, right? For our minor subjects also, we will have the focus, but to score a very high marks on your mains paper, major subjects should be extremely clear. Your CPC, and suppose your Indian Contract Act, and your criminal laws, CRPC, BNS, BNSS, IPC, BNS, Indian Evidence Act, BS. Okay, these are your major subjects. So they obviously in CPC there are not just sections, there are orders and there are rules. So when we talk about other acts and other legislations, we know we have to only remember the sections. But in CPC, you have to remember the sections, you have to remember orders as well as rule. There are around 51 orders, so we will also be telling you what are the important orders that you have to focus on. CPC is a huge subject, and sometimes the weightage of it is almost 150 marks out of the 200 mark paper. So CPC will be dealt with very extensively, that everything basic about it, every important aspect of it is covered properly. So nothing will be left out. All your questions will be dealt with very nicely. So basics will be dealt with properly, questions will be dealt with properly. We will also work on how to answer the questions properly. So this is your mains paper. Civil and criminal law, you know what I'm going to do with it, know what our faculty is going to do with these papers to address the paper properly. But when we talk about our GK paper and we talk about our English Hindi paper, we will also deal with these. We will not be able to deal with a lot of local languages, but we will deal with English and Hindi and your GK papers. So in GK papers, usually there is how you are going to, like, they will ask you a question related to a legal development and you will have to answer it in a paragraph form or maybe in an essay form. So we will give you very current legal developments to answer and also provide you model answers for the same, so that you stay updated with your GK, your current affairs and your legal developments as well. And for English, we will also deal with your translations, we will deal with how you address the précis, we will deal with how you deal with your compositions, and of course how to write a perfect essay. These subjects can also, these papers cannot be left out because they help you make an edge. Now when your mains results arrive, only these papers, they help you make an edge in the interview when you reach the interview. So you have to make sure that not to leave them out. They are of equal importance as much as your law subject papers. So we will also focus on these mains papers. And for local laws, wherever there are local laws, we will hand out to you notes as and when your state notification arrives, and when you approach us for this, we will also hand out to you notes and the question and answers, how to deal with them properly. So we will not leave out any part of your journey. Make sure that your prelims to mains is extremely clear and no part is left out, even in the classes or as well as in the handouts that we will be giving to you. And your third stage, of course, is your interview. And we will provide you interview guidance program for this also. But to reach this stage, these essential stages are extremely important. There will be test series as well that will be available to you for at least a 3 years period online. Your lectures will also be uploaded. They are recorded and uploaded on your website. So you can access them anytime. If you miss a class, you can see the recorded lectures. So this is the whole judiciary batch work strategy, how it's going to be, and everything will be covered properly. No part of your journey will be left out, and no part of the exam will be left out. When the notifications arise, they will be notified to you. All the key changes, answer keys, they will be given to you beforehand. Questions will be discussed of your prelims as well as your mains. So everything will be targeted properly, and this whole format, your prelims to your interview journey, in 16 months we will deal with properly. Okay? So this whole journey will be dealt with properly. Okay, this is clear, everyone. I hope this is very clear. I've made clear what our next 16 months is going to be like. So if there are any questions, you can ask me. Are there any questions? Okay. So today is our first class of contracts law. So I'm going to start with contracts law today. Now we are going to deal with contracts law. I've made clear how the classes are going to work, how each subject will be approached, and what our next 16 months are going to be like. And for our introductory subject that I'm going to deal with, I am starting with contract law, and Aditya sir is starting with constitutional law. So with contract law, we are going to start with basics. We are going to start with very basics, and we will go on to explain what all important sections are there, what all important topics are there. Okay, so whenever you are here for a class, you have to make sure that you have the Bare Act, because for your prelims exam, your Bare Act is extremely important. It should be imprinted on your mind for every subject what each Bare Act says. How many sections are there? How many chapters are there? And because sometimes in your prelims exam they ask specifically how many sections are in this Indian Contract Act, and then they will give you options for it, or how many chapters are there. Sometimes they will ask you what is chapter 5 of Indian Contract Act. So for your prelims exam, you should know that the index of your Bare Act should be imprinted in your mind. This is very important, and sometimes maybe it is difficult to imprint and learn the whole index properly. So what will help you is that if you repeatedly answer multiple choice questions regarding these sections. If you answer these multiple choice questions repeatedly, then it will be imprinted in your mind that suppose your section 2A, it belongs to proposal or offer. Okay? Or suppose your section number 17, it belongs to fraud in your Indian Contract Act. So when you're continuously doing these MCQs of the particular sections, they are usually imprinted in your mind. So this is one tip that I would like to give you for this. But to start with any subject, what we need to understand first is that we have a Bare Act in our hands, and the Bare Act, the index of the Bare Act, and it should be imprinted in your mind how many sections are there and how many chapters are there. So for your contract law before its codification, before it came, how did we work out the contracts? So it was based on your English law, English common law. So in the British colonial period, your English common law and your customary law. So customary law plus your English common law. In your pre-British period, this governed the contracts in the British colonial period. Now this led to a lot of unpredictability, non-uniformity, okay, and a lot of confusion that what will apply to what person. So there was a need for codification. There was a need for codifying your Indian contract law. There was a need for codification. So that's when an Indian Law Commission was set up, and they codified the Indian Contract Act. This Contract Act is of 1872. Now Indian Law Commission was set up, and in 1872 this Indian Contract Act was codified, and it came into force on your 1st September 1872. This date is important because in your prelims exam they repeatedly ask you this a lot of time on what date your Indian Contract Act was enforced. So what I mean to say is, when you're reading the Bare Act, when we are going about and I'm telling you if this is important, make sure to mark a star on that topic, and just remember that when we are going on a subject is going on, anything can be asked from it in your prelims exam, and us telling you what it is going to be, you should make a note of it so that it's easy when you are approaching your prelims. Maybe then you won't even have to revise, and it will just come to your mind that this was given in class and this was noted in class. So 1st September 1872, Indian Contract Act came into force, and this is when it came into force. This date is extremely important. So it was codified. It was the earliest civil laws in India which was codified at that time, and it is still in force with very minor amendments. So what was the structure? There was the earlier structure of Indian Contract Act. It consisted of 11 chapters. First, there were general principles of contract. Second, there was SOGA, your Sale of Goods Act. And then there was Indian Partnership. And then there were all special kind of contracts like your bailment, pledge, indemnity, guarantee. Okay, this was before it was before the present, how the original structure of Indian Contract Act was. It consisted of your 11 chapters, and this was the whole structure. But after 1932, some parts, some chapters, they were repealed and they were removed. Like SOGA, it was repealed in 1930 and it made its own act, that is your Sale of Goods Act. Okay, and Indian Partnership Act in 1932, it was repealed and it also was codified in its own act, which is your Indian Partnership Act. And this information is also important because in your preliminary exams, again, they can ask you in which year SOGA was taken out of ICA and made into its own act, and in which year was Indian Partnership Act taken out and made its own act. Okay. So this is how the present structure is. Your present structure now, it consists of two parts. Present structure will consist of two parts, which is your general principles of contract. General principles of contract, which is your section 1 to 75. And second part is your special kinds of contract. Special kinds of contract. Special kinds of contract, they are divided into three parts. First part is your indemnity and guarantee. First part will be indemnity and guarantee. Second part, indemnity and guarantee. Second part is your contract of bailment and pledge. And third part is your contract of agency. So this is the present structure of your Indian Contract Act now, and this is how we are going to deal with it. First, we are going to deal with the general principles of contract. Your general principles of contract, they will cover everything from formation to validity to performance of the contract and discharge of contract. It includes all your important topics, your contingent contracts, all the important terms of the contracts. We will deal with them one by one with all the major case laws. And then your special kinds of contracts, they are also very important. Contract of indemnity and guarantee, they are repeatedly asked in exam. Contract of bailment and pledge, and contract of agency. Contract of agency is very important, and now bailment is also very important. There is a trend of asking questions from bailment repeatedly these days in your judicial services exam of various states. Like there was a very exhaustive question on the topic of bailment in your previous year DJS exam. So it is also very important. So this is how we will be dealing with the whole Contract Act. So to give an example of how a Contract Act works, like when it comes into operation, suppose you go to a website like an OLX and you see an iPhone, and you offer that I'm willing to buy this iPhone for, suppose, say 30,000 rupees. So in this whole transaction, is this a contract? Will you say that this is a contract? Will you say a contract is formed? We are just going to deal with an example to understand what our basic strategy is going to be, how we're going to deal with understanding the general principles of contract. So when there is when we make an offer, suppose on OLX, like I am willing to buy the iPhone. So I am willing to buy, there is an offer, this is check, and if the person accepts that okay, you can buy, I am willing to sell, then that is your acceptance. When offer plus acceptance, they come together, there is an agreement. And when there is an agreement, there is a contract. But this agreement should have legal enforceability to make a contract. Now what do we mean by this? I am giving you an offer that are you willing to sell your iPhone to me for 30,000 rupees? This 30,000 will be considered the consideration, of the transaction. Now there is an offer, there is an acceptance of the offer, there is a consideration, and it is on a commercial platform, OLX. So there is a presumption that whenever there are commercial transactions, there is a legal intention to go to court. Legal intention to create an obligation. There is an obligation on the part of the seller to give the iPhone and an obligation of the buyer to give the money that he has contracted for. Now whenever there is a commercial transaction, we presume that there is also the intention, the legal intention to create obligation, and if he didn't do what we are saying in the contract, we can also go to court. We can sue if the obligation is not obeyed or fulfilled. So basically these are very basics of your contract, and we will be dealing with these general principles in much more detail in the whole class. So the offer is going to be there is an acceptance, there is a consideration, and there is a legal intention. Now this is just basic, so you have an idea, okay, this is a contract. But now in our classes we will be dealing with what is the lawful offer, how is it made, when can it be revoked, what is a lawful acceptance, how is it made, and when can acceptance be revoked, and what are the consequences of revoking an acceptance. What is consideration? What is consideration? What is past, present, future consideration? What kind of contracts make, what kind of agreements the considerations are void? How important is the consideration? what is privity of consideration, what is privity of contract. All this we will be dealing with on all our classes in contract law as and when we go on. So contract law, we will start with very basics and we will move on slow by slow, little by little, to the whole mountain of answering questions that come out of literally 1 to 2.5 pages sometimes in your mains exam, especially in your Delhi Judicial Services. We are dealing with basics. We're dealing with basics, and this will answer your straight questions. Sometimes your questions are very straightforward in many exams like RJS, or you can say UP Judicial Services. The questions are very straightforward. Like, what is an acceptance and offer? Give the difference between agreement and contract. So these are very straightforward answer, and they can help you score 10 marks. They might be of 15 marks, and we will tell you how to structure the format of these questions as well. But these are very simple, okay? You know that you have to write the section, the case law, the illustration, and you will be able to score a whole maximum mark on the question. So these are your straight questions that come in the exam. But then there are questions that come from that are problem based. Secondly, then there are questions that are problem based. So how to address these problem based questions? Like, they would ask you in a contract law, a problem based question could be that whether this contract is void. They might give you a situation like a contract is signed by a minor, and now is this contract void or not, and then you explain the principles. So until unless you know the relevant section for it, you know the judicial precedents for it, you will not be able to answer the problem based questions. Problem based questions, usually they come out of the numerous illustrations that are given in the sections of your Indian Contract Act. So we have to also focus on that. You should not miss out any illustrations, because illustrations, they make these problem based questions. Now we will also tell you how to address these problem based questions. This is one thing, but then there are really big questions. Now these big questions, sometimes of 20 marks, 30 marks, and they are interplaying various provisions. They are playing Indian Contract Act with SOGA sometimes. They are playing Indian Contract Act with CPC sometimes. They are playing a lot of sections of one particular act with your other acts. So we have to also focus, we have to also understand how these sections can interplay. Suppose, let's take breach of contract. Breach of contract is in your Indian Contract Act. What is the compensation for the breach of contract? We will deal in section 73, section 74, then 75. Okay, compensation for breach of contract is given in here. Then in CPC, we have breach of contract consequences. What are the consequences of breach of contract? This is given in your order number 39. So at one point, little by little, after we learn the basics, we build up our whole concepts clarity. Then we will also reach the part where we will relate two provisions of one act to the other act. Okay, so that's how we are going to deal with our mains questions as well. So now I hope you have understood what we mean by interplaying sections. This can be a little confusing if you are a beginner, but we have to reach that level when we are understanding a subject, because only then we will be able to crack at least our exams like Delhi Judicial Services, Haryana Judicial Services, Rajasthan Judicial Services, these judicial services, there is a trend of asking more and more problem-based questions now rather than your straightforward questions. So we will deal with how to address these questions properly. So coming back to our Indian Contract Act, we understood what the basics were. There is an offer, there is an acceptance, and there is a consideration and an assumption that there is a legal intention to create an obligation, otherwise we will go to court. This is a contract. Now this is a contract when all these essentials are there. In contrast with, let's say, an agreement that I say I promise to take you to Goa if you do well in your exams. So now this kind of agreement, and I don't. So this is a domestic and social arrangement. If I'm making such a promise to you that if you pass your exam that I will take you to Goa, then this is like a social or domestic arrangement. It does not create a legal obligation. You cannot come sue me if I don't, like you excel in your exam and I still don't take you to Goa. Then you cannot come to sue me for this. So agreements that are domestic or social and agreements that are commercial, we have to do the objective test. There is an objective test that we need to do for every contract. So if the objective was to create a legal obligation, it is a contract, and if the objective is to create only a social or domestic arrangement, then it is not a contract. So this basic should be in your mind when you're dealing with contracts. So this is one thing to understand the difference. There is also a very landmark case of Balfour versus Balfour, 1990. See, for your citations, your year is very important to remember. Maybe if you don't remember the whole citation, it is okay, but for major fundamental case laws, you should also remember the citations as well, like for Keshav Nanda Bharti versus State of Kerala. And for this major case laws like Balfour versus Balfour, there are landmark case laws that should be on the tip of your hand when you're dealing with the subject. So this was in 1990. You should remember the year for each case law. So in this case law, there was a husband and a wife, and the husband promised the wife that he will give the wife a particular amount every month, and then he did not. He stopped giving her. So the wife went to court. The husband came and said that this was a domestic arrangement. It was not a contract. There was no intention to create a legal obligation. This is a landmark case law to distinguish between your contract, agreements that form into contract, your commercial agreements versus your social or domestic agreements. So we will deal with it in detail later, but I would want to give it to you now that this is how the objective test is, and this is essential to understand that it's essential to understand that what the agreements that form into contract because of commercial transactions and agreements that are just social or domestic arrangements and they do not form into your contracts. So moving on, we know how contract law was codified. Okay, we know what's the structure of the contract law. We know what is the basics of contract that we are going to deal with, what are the principles of contract. Now let's start with our opening section number 1. What is your section number 1? And I'll quote, "This act may be called the Indian Contract Act, which and it extends to the whole of India." This is your section number 1. So originally the act did not extend to your Jammu and Kashmir. This part is important to understand because this point also they repeatedly ask in your preliminary exams, and they can ask you if the Indian Contract Act now extends to Jammu and Kashmir, or through which act in Indian Contract Act now extends to Jammu and Kashmir, because there's nothing in Indian Contract Act that is saying there's something in the amendments, but on the face of it you will not see that it extends to Jammu and Kashmir. So it now extends to Jammu and Kashmir because of which act? Because of our Jammu and Kashmir Reorganization Act. Because of our Reorganization Act 2019. So before the abrogation of Article number 370, Indian Contract Act, it did not extend to the whole of India. It extended only to the India except for Jammu and Kashmir. But after the abrogation of Article 370 because of Jammu and Kashmir Reorganization Act, now all the central laws, what does this act says? That all the central laws are now applicable to Jammu and Kashmir. So your Indian Contract Act is one of your central laws. Now this is applicable to Jammu, Kashmir plus Ladakh as UT. Okay, so Indian Contract Act is now applicable to the whole of India, including Jammu, Kashmir and Ladakh as Union Territory. So why I am focusing on section number 1 is that when they ask you multiple choice question, in the first option they can say one thing, in the second option they can say another relatable second thing, and also very confusing something in your third option. So you have to have this thing clear that before Article 370, before this act, what was the status? Indian Contract Act extended to the whole of India except Jammu and Kashmir, and after the abrogation of Article 370, what was the status? That now Indian Contract Act extends to the whole of India by virtue of Jammu and Kashmir Reorganization Act 2019. They might also ask you the name of this act. They might confuse you with the year as well. So be clear with the terms and the knowledge, because for preliminary exams you have to be very careful, you have to be smart to answer these questions properly. Okay, so this we dealt with the extension of the Indian Contract Act. Next, we will deal with the scope of the Indian Contract Act. What is the scope of the Indian Contract Act? The scope is that it does not apply to moral or social agreements. If there is a moral or social agreement, then Indian Contract Act will not apply to it. If there are promises within the family or promise with a friend, then you cannot avail the sections of Indian Contract Act for it. Secondly, for religious or personal laws based obligation, for example like dowry or marriages based on personal laws, like suppose we can say for nikah, it is a marriage based upon personal law. They cannot invoke the provisions of Indian Contract Act in case of a divorce under Muslim personal law. So the scope is that it does not govern moral and social obligation. It does not govern moral or social obligations. Secondly, it does not govern religious, personal laws or religious obligations. Thirdly, it does not govern unenforceable agreements. What are your unenforceable agreements? Unenforceable agreements are those which lack intention, or they lack consideration, or they lack the legal object. So you cannot avail the provisions of Indian Contract Act for it. But Indian Contract Act, to talk about the scope, it applies to your commercial contracts, trade related contracts, your business contracts, all the commercial contracts Indian Contract Act applies. Obviously we already know that. Then your employment contracts, Indian contract apply to your employment contracts. Thirdly, online contracts as well. We will deal with e-contracts. What are e-contracts? There is a trend of asking questions from e-contracts. So your online contracts is your next point. And fourth, where Indian contract applies, is your insurance, your real estate, your service contracts, and corporate transactions. So this is the scope of your Indian Contract Act. They can also ask you in your preliminary questions. They might ask you a problem-based situation and make you do the objective test whether Indian Contract Act will apply here, whether Indian contract is related here or not. So it is important to understand that moral and social obligations in the Indian Contract Act, they do not, Indian Contract Act do not apply to them. For your personal laws and religious obligations, the Indian Contract Act does not apply, and for also unenforceable agreements. And for your commercial contracts, Indian contract applies. For your employment contracts, for online contracts, insurance, real estate, service, corporate transactions, all of there your Indian contract applies. And because it applies to all these categories, all the case laws relating to these categories become important to us. Because what the Supreme Court is saying about commercial transactional employment contracts or real estate contracts, they all become important to us. Because sometimes they take out the facts from the case laws itself and they want us to tell what provisions apply to this particular facts in the judgment of the case. So we will keep a track of all these cases, all the recent cases when we are dealing with contract law. So moving on, I hope you have gotten till now what is going on. We dealt with codification, we dealt with structure of the contract, we dealt with the basics, principles of the contract, and then we dealt with the objective test, the extension of the contract, and the scope of the contract. So we will deal with more of these topics, like we will move on to definitions of the contract in the next class, and we will extensively deal with the types of contract. Then we will deal with the essentials of a valid contract, and we will deal with all of them one by one and keep noting down the important questions and the important topics for these. So till we will wrap up the class here. This is how we will deal with each subject. We will, in the class itself, we will keep mentioning what important topics are, what important judgments are. This is just very basic of contract law. This will get more complicated as and when we move on to more complicated sections. There are some sections where the sections says something on the face of it, prima facie it says something, but in reality the implication of the section is different when it comes to reading the judicial precedents about it, when we are reading the judgments of it. So what is the real application of the section, that also we will note down. Like for example, for your section number 74 itself, which deals with liquidated damages, this section says something prima facie, but a lot of case laws came after it which clarified what the section's meaning was it. So we will deal with what is the interpretation of the section as well, and what the section says prima facie as well. So your contract law will be done with very beautifully, so that you answer smallest questions to the most complex ones properly. So this is your class for today, and I hope I have cleared everything. And if there are any questions regarding this, please you can ask me now as well, and you can also contact our management if you have any queries regarding our foundation batch. You can contact the management, and if you want to apply or you want to join our classes, then also you can contact the management for it. So thank you everyone for your patience. I am closing the class now. Thank you for the class, and I'll see you in next class.